Welcome to this video, which is part of Norton Rose Fulbright's series on financial restructuring issues around the world. I'm Kei-Jin Chiu from Norton Rose Fulbright in Singapore, and with me today are two friends and colleagues, one from Norton Rose Fulbright in Sydney and the other from Norton Rose Fulbright in Amsterdam. I'll let them introduce themselves to you now.
Hello there, I'm Noel McCoy and I'm from the Norton Rose office in Sydney.
Hi all, my name is Omar Salah and I'm a partner at the Norton Rose Fulbright offices in Amsterdam, and I'm also a professor in law. I hold a chair at Fulbright University on global finance and restructuring law.
In this episode, Noel, Omar and I will be looking at some of the restructuring solutions in our respective jurisdictions. If at the end of the video you have any questions or would like us to explore some of the issues raised further, please do visit us at nortonrosefulbright.com. So let's start with Singapore. The main restructuring tool here is what we call a scheme of arrangement. It's basically a plan to restructure a company's debts by offering the creditors a compromise payment for what they're owed, which would then put the company in a situation where its debt burden would be manageable and it would be able to continue as a going concern. The great attraction of a scheme of arrangement is that it usually gives the company and its creditors a better result than if the company were to be put into liquidation. The creditors recover more than they would otherwise have, and the company is given a new lease of life with all the benefits that would come with that, such as jobs retained and a continued contribution of the business to the communities that it has a presence in. A scheme of arrangement has to be approved by the creditors, and to help the whole process, what happens here is that a company can get a court-ordered moratorium on all its debts to give the company some breathing space. It usually starts with an automatic moratorium for 30 days, which is then followed by subsequent extensions, depending on how long the company will need to come up with a scheme of arrangement, which can then be put to the creditors for their approval. There are two interesting features of the restructuring regime in Singapore, which I would like to highlight. The first is that it allows foreign companies to avail themselves to this solution or tool in Singapore. There is a criteria to qualify for this access to the courts here, but in many cases, it's not a difficult one to satisfy. The second feature is that we have adopted the Untitled Model Law on cross-border insolvency. It provides an effective mechanism for the countries which have also adopted the model law to cooperate on administering cross-border restructurings by, for example, recognizing orders made by each other's courts to protect the value of the company's assets. The combined effect of these two features is that it makes multi-jurisdictional restructuring much easier, which for global companies is a crucial consideration. Multi-jurisdictional restructurings are not uncommon these days. And indeed, Noel, Omar, and I, along with colleagues in London and New York and elsewhere, have for the past year been working on a global restructuring of a business which has a presence in Europe, Asia, Australia, and the United States. Now that's enough from me. I will now hand you over to Noel, who will tell you something about what is available in Australia.
Thank you, Kei-Jin, and I think that's a very nice segue because that restructuring that we collectively worked on gave us an opportunity to consider Australia versus Singapore versus UK restructuring procedures for entities that had connections to all of those jurisdictions. And at least from an Australian perspective, one of the reasons for looking at those other jurisdictions are some of the limitations, particularly when you talk about schemes of arrangement. Kei-Jin just mentioned some of the tools that are available in connection with schemes of arrangement. The scheme of arrangement is also available in Australia but it is due to the strict sort of threshold and procedural requirements, and oftentimes the costs and the complexity of implementing them. They've traditionally been reserved for large-scale and publicly listed restructurings, and so will oftentimes not be suitable. Indeed, in the last decade or so, there've only been 17 creditors schemes that have been approved in Australia. So the scheme is available. There is the possibility of obtaining a moratorium similar to what KGM was referring to in Singapore. However, the procedural requirements are quite hefty, and so it is not oftentimes that it is the tool of choice. Much more commonly in Australia is the voluntary administration, and in the more recent past, the Virgin Australia administration is perhaps the most well-known of these, and was able to achieve a successful restructuring of that business, and is now Virgin has now relaunched in Australia and is operating. And one of the benefits of the voluntary administration process is that it has quite a degree of flexibility. I think over time, even though on paper it doesn't necessarily provide some of the tools that one would like to see and that are available in other jurisdictions, between practitioners, lawyers and the courts, they've been able to fashion voluntary administration into a more flexible tool that's able to achieve things which perhaps were not originally contemplated. And that's largely due to an important provision in the voluntary administration provisions. Section 4470A of the Corporations Act gives the courts the power to change the operation of the voluntary administration provisions for a particular administration. So that with court sanction can enable a great deal of flexibility, which on paper does not first appear. And so facilitates things like what is commonly referred to in other jurisdictions as debtor in possession finance, and other kinds of tools that facilitate a successful restructure. So voluntary administration tends to be the tool of choice. And interestingly, while traditionally it had been oftentimes derided as the route to the slow route to liquidation, in more recent times, it's seen greater success in achieving restructurings. In fact, during the COVID period, the recent statistics show that even though the use of voluntary administration was down, the number of successful restructuring plans has increased. And that goes to the heart of what a voluntary administration does. All creditors get to participate in the decision of the company's future. A voluntary administrator is appointed, so it's not a debtor in possession restructuring tool, but the ultimate outcome is decided by a meeting of creditors. All classes of creditors vote together such that the restructuring plan is decided by a majority of creditors in number and value. And so in that sense, there is an automatic or a cross-class cram down, because all classes are together and are voting. Secured creditors have particular carve-outs that if they don't support the restructuring plan, their security interests can be protected. But as I've mentioned, that there have been some ingenuity amongst the professionals involved and the courts, which has enabled successful outcomes, and that has been the key. But I think what Australia is hoping to move towards is a more friendly debtor in possession-led solution. And also currently the Australian government is looking at schemes, particularly in the context of what we've been seeing in Singapore, also in the United Kingdom and other jurisdictions. I'm sure we'll hear from Omar about their innovations in a second. And Australia is looking to those, and in particular in the scheme of arrangement context, as KG mentioned, the Australian government is considering whether to introduce cross-class cram downs in the scheme of arrangement context. So that's a very brief overview of the key Australian tools. And with that, I'll hand over to Omar.
Thank you very much, Noel. And it's very fascinating to hear about what's going on in Australia. Also good to get the update on Singapore, because if we look at the Netherlands, where I'm based, I don't think we can look at the Netherlands in isolation of what's going on in Europe. So looking a bit broader on what's going on in Europe, we've seen a big driver for insolvency law reform with the EU Restructuring Directive. that has actually resulted in many jurisdictions introducing new restructuring proceedings. We've seen the introduction of the Star route in Germany. Italy has announced the introduction of a new restructuring proceeding with their Code of Crisis. And France actually already made some amendments to their existing restructuring proceedings to comply with the EU Restructuring Directive. In a similar way, we have seen the introduction of the VOA in the Netherlands. We often refer to it as the Dutch scheme. And it's very much in tune with what I've heard about developments in Singapore from Kejin on the Singapore scheme and what's going on in Australia as well, as you mentioned, Noel. If we look at the Dutch scheme, it's, I think, first of all, quite important to note that before the introduction of the Dutch scheme, the restructuring options in the Netherlands were limited. Most companies went into a bankruptcy proceeding, which often actually results into liquidation. We have a suspension of payment, which is another restructuring proceeding, but was not successful in practice in most cases. We have seen some recent cases where some innovative tools of the suspension of payments have been used, but still one of the most important drawbacks of the suspension of payments was that it did not affect shareholders, and also not secured creditors. So with introduction of the Dutch scheme, that has been a major shift with a new tool that is based on the US Chapter 11 proceeding and the UK scheme of arrangement, combining elements of both. And it actually is a restructuring proceeding that is, I would say, on par with some of the more advanced restructuring proceedings throughout the world. So if you look at the Dutch scheme, we can see that it's a debtor in possession proceeding. It has some features that are very common in schemes and Chapter 11 proceedings, like the cross-class cram down, which we see in the Chapter 11 proceedings, ipso facto deactivation. It allows for the restructuring of group companies. And what is quite interesting about it is that it is also accessible for foreign debtors. So foreign debtors can also actually use the Dutch scheme to restructure their debt. If we look at what we've seen in practice so far, what is striking is that in the first year of its enactment, it was mainly used by SMEs. So unlike many expectations, we've seen that a lot of SMEs use the Dutch scheme successfully in various restructurings in the first year of its enactment. Now that we're in the second year of its enactment, we can see that larger corporates are also looking at it with much interest. We have seen some restructurings where it's been used already and we've been advising. So we can see that it's actually reaching, I would almost say, a second stage of its development in practice. And there's been a lot of case law so far as well that also gives guidance on how the courts in the Netherlands are dealing with the Dutch scheme. And it actually provides some very interesting insights and also legal certainty as where we may be heading to with the Dutch scheme in the foreseeable future. And listening to what's going on in terms of developments in Singapore and Australia, and also reflecting on what we've seen in Europe on the ground, it seems that this entire wave of insolvency reforms and advancing scheme proceedings seems to be a global trend where hopefully we as restructuring professionals can benefit from. And with that, that brings us to the end of this video brought to you by the Global Financial Restructuring and Insolvency Group of Norton Rose Fulbright. Thank you very much for watching. And if you have any questions, please reach out to us. You can find our contact details at nortonrosefulbright.com. Thank you again.
Thank you.
Thank you.